consequences are. So what happens if there is an incapacity? So there are a couple of things we can do, and I want to mention these because they go also to what happens when a contract might be suffering from uncertainty. Now that's confusing because certainty is it's an element of formation. So if a contract is uncertain, then we don't have a contract, technically. But what the courts will do, as you remember, is it's better to give effect to something, particularly if there's been part performance, than not. So these same rules apply, and we talked about them in a broad sense last week, but I just want to make sure you're aware of them. So if the contract itself as a whole is oppressive, then the whole contract will be struck out and no part would be enforceable against the minor. But if only part of it is objectionable, then the substantive elements can be saved by the simple expedient step of excising or severing out those clauses. So let me give you an example. If a contract is for the beneficial services, I'll use Wayne Rooney as an example, and this is a contract with his football team, and the football team says that it will provide training and accommodation, a range of different things, but it requires Rooney to own 50 pairs of tap shoes. Just because they're sponsored by, I don't know, a tap dancing company, and he needs to wear they want him to wear different tap shoes. It is highly likely that the requirement that he buys 50 pairs of tap dancing shoes would not be considered a necessary. It would not be considered a relevant part of the beneficial contract of service. And provided that the rest of the contract could continue, you could sever out, cut out, excise that particular clause, and the rest of it could run. So that means that if Rooney didn't buy and wear 50 pairs of tap shoes, he would not be in breach of the contract. But if he didn't show up for training, or if he tried to change teams mid-season, he would be in breach of the contract. Courts don't take severance lightly. The language includes using a blue pencil. I don't know why it's a blue pencil. That seems really wussy. I use a red pen. But a blue pencil, if you can actually just take out those clauses and read it in a way that makes sense, then you can sever. Severing must not alter entirely the scope and intention of the agreement. A severed clause must be clearly distinct from the part remaining, and the remaining contract needs to be able to stand on its own. For the next assignment, many of you will take Dennis's advice and you will go and have a look at the Encyclopedia of Forms and Precedents, and you will use that to inform yourself about what kind of contract or kind of changes might need to be made. By the way, if I'm going to say this once, I'm going to say it 100 times, you are not being asked in that assignment to write a contract. You are being asked to advise on what's missing, how things might change, what you would put in, what you would do differently. You are not required to present me with a draft. Okay, just in case. So, you will see when you look at example contracts, and a good place to start there is to look for what are called the boilerplate provisions. Or boilerplate contracts. So boilerplate is legal jargon. It effectively refers to a group of standard clauses that you would see in many agreements. Many boilerplate provisions actually arise or have been created to avoid getting ourselves into situations where the common law would say that something will happen. So, for example, severance is a really good example. Almost every agreement that is in writing, wholly in writing, will have a severance clause that will state the circumstances, what will happen if a clause or if something is ineffective or doesn't work. And the standard way to do it is to say what the common law says actually, which is if any part of this agreement is unenforceable, then, and we can sever it out and the rest of the contract will work, then that's what we're going to do. But they might say things like, if any part of that clause that deals with confidential information, or that clause that deals with how I get my money offshore into a different tax account, or something specific, if any of that is unenforceable or doesn't work, then the whole contract is unenforceable. The parties could agree that. So remember, in contract you can pretty much do anything you like as long as you're prepared to pay tax and not draw blood, as long as you're clear. Now there are a few things where the law says, yeah, it doesn't matter what happens, you can't override this. For example, a provision in a contract that says you can't take, we exclude the courts from our disputes, that will not be enforceable. But if we say something that's different from how the common law would deal with it if we didn't say anything else, then that, if the parties agree it, they have intention, we have proper formation, then everything's rosy pretty much, unless you hit illegality. So then we have this idea of the voidable contract. So that's a situation where the person who has either the benefit of a clause, or in this particular context we're talking about a minor who has the benefit or the ability to void the contract. We have a couple of different types. So the first type in relation to minor are where you've acquired an interest in something of a continuous or permanent nature. So land, leases, company shares, partnerships, and I've just remembered what the answer to your question is. Anna, the question you asked me during the break is about to be answered here, and it actually comes from the Supreme Court Act or the Evidence Act, wherever we're going next. So basically the law says here that in relation to those permanent, any contract matter with a permanent ongoing subject matter, so shares, ownership of land, that kind of thing, can be repudiated during the minority or within a reasonable time after gaining majority. So in other words, it exists unless and until the minor says, no, I'm repudiating this, I'm pulling out of this contract, except for the fact that the legislation effectively says, no, we don't care, just don't do it. So that's this permanent and continuous subject matter, voidable by the minor. So if a minor repudiates a contract and the obligations have already accrued, it's less clear as to what happens. Because if you've got something that's voidable, that means one of the parties has the option to bring yourself back to the position if the contract had never happened. Excuse me. But of course, if the subject matter of the contract has been used, destroyed, merged in with something else, time has passed, its value is different, where the other party has actually done all of the things that they promised to do, it's very hard to go back to that first position as if the parties hadn't actually done anything. So when repudiating a contract, a minor will be entitled to recover any land that they've transferred to someone else, or if they've transferred goods, they can recover those goods if the minor hasn't received any of the consideration. And then again, legislation can impact this. Each state is different. South Australia has its own Minors Contracts Miscellaneous Provisions Act, for example, and the court can order restitution. So here we're really talking particularly about circumstances where the minor was the owner of land and it transfers. Remember too that a lot of these cases are really old. So particularly the way that the common law's developed, owners of land, land used to pass through inheritance. So when Dad heads off to the Crusades and doesn't come back, the infant child becomes the owner Now, they might not actually have legal capacity to do anything, so somebody else has to stand in and do those things for them. But a lot of these laws have arisen as a consequence of a minor child being effectively talked out of selling the family farm or talked into selling the family farm. So the cases tend to go the other way from what you were asking me about. Then we have the other side, the contracts that are not binding unless they're ratified. So Section 50 of the Supreme Court Act basically prevents proceedings on the ratification of a contract made while a minor. So it doesn't really matter. This is actually not useful to us at all anymore. So the fact that you've entered into a contract and later on you say, okay, I will ratify this contract, it doesn't matter. You can't be sued on that ratification. So if you are a party to a contract with somebody who has recently become an adult, you made the contract previously, the adult says, don't worry about it, I intend to be bound by that, so I'm ratifying the contract. Section 50 of the Supreme Court Act says, bad luck, you still can't sue on it. So you would be better off making a whole new contract or ensuring that the ratification was in a deed so that the existence of a contract doesn't matter. And this is particularly relates to non-necessaries and the like. Okay, so we've got these two forms of contract that are voidable, and these contracts here, necessaries and beneficial employment, are binding. Sorry, yes, Craig.
What did you do to ratify?
Not very much. Doesn't really matter in this context, but not very much. So it could be a verbal specific statement that is recorded. It can be a document or a letter. There's some details in the textbook that talk about it, but the standard for ratification has not been held to be a very high one. Anything that demonstrates that the person who's achieved their majority understands the obligation and intends to be bound by it. So non-necessaries, it's worth noting, title to goods that are non-necessaries pass to the minor through delivery. Now, when you do commercial law, you will learn about sale of goods and transfer on delivery, etc., and it's basically the same rule. Once the goods are delivered, the title in them is transferred to the minor, but the minor can't be required to pay for them. Hence why, if you run a shop and you're dealing with children, you take the money before you let them take the goods. If the kid has already paid for it, they can't recover payment. Non-necessaries that are obtained by fraud can be recovered during the using the doctrine of restitution if the trader can show that the property is still identifiable and the minor still possesses it. So once a payment has actually been made, and actually going back to a point I made earlier, when you think about a prepaid phones, this is, even if it's a non-necessary, once it's paid for, so there's no particular issue in relation to it. But if the phone account was of an inordinately high number, necessary or unnecessary, then we've got the element of fraud that comes in as well. So non-necessaries obtained by fraud can be recovered using a doctrine of restitution. I think we've talked about that. Oh, here you are. What's involved in ratification? Have a look at the slides. Contracts with minors which require ratification are not binding on the minor unless they're ratified. Accordingly, a minor will not be bound by any obligations under the contract unless you ratify it. So the other side is still bound. You've handed the goods over. Your promise was to deliver the goods. Consideration is the exchange of promises. I promised to give you the tap dancing shoes. You promised to pay me for them. Tap dancing shoes have been handed over. Title passes to the minor. Requirement to pay for them, only required if they are a necessary. So it's quite there's a potential for fraud on the vendor if the vendor has no reason to understand that we're dealing with a minor or an incapacitated person in another respect. And so, but effectively the law is placing the onus on the vendor to take particular care with young people or drunk people or people who are psychologically infirm. Other relevant provisions here is Section 49 of the Supreme Court Act, which says these kind of contracts are void all up. Contracts for the repayment of a loan, contracts for the payment of goods that are not necessaries, and accounts stated. So an account stated is when the minor admits that they owe money. So some sort of document saying, yeah, I crashed your car, I owe you for the repairs. That would be an account stated. So Section 51 says that promises by a person on attaining majority to repay a loan will be void. So you will remember I mentioned before that a contract for the sale of goods that are necessaries might be voidable, but lending the minor money to pay for the goods, you won't be able to enforce that. There's even when they ratify it subsequently, if the minor doesn't want to repay the loan, it is almost impossible to capture it, which is one of the reasons why when you're looking at those finance contracts for the computer, that they just will not enter into contracts with people who are under the age of 18. And so the slides here then provide the language that you might have to look at. It's not quite as complex language as we looked at last week. Following contracts entered into by a minor are void: contracts for the repayment of money lent or to be lent, contracts for the payment of goods supplied or to be supplied other than necessaries, and accounts stated.
Sorry, that accounts stated, what was that again?
Account stated is effectively a statement that you owe money to someone. So the example I gave was, I crashed your car, I agree I owe you the money. Okay, so it always amuses the people in the other states to realise, like in Victoria, age of majority also matches the time that you can drive a car not under supervision. And so often these kind of issues come up in other states when you've got a 16 or a 17-year-old who has been driving, might not have been complying with the rules of their P plates, insurance doesn't cover an accident. They might then admit that they are at fault and promise to pay the money, but because they are a minor, they can't be held to that. Everybody's like, who did I lend my car to? So this is Section 50. So no proceedings can be brought to charge a person. So we saw that language last week, charge a person on a so that just means sue them. Well, I don't know why they don't say sue them, but they say sue them. They say charge a person on a promise made when they grow up to pay a debt that they entered into when they were a child, or on a ratification that they made as an adult of a promise that they made before they became an adult. It's worth noting that in 51(2), a person who in good faith, for value and without notice is the holder or assignee of an instrument that might have this loan instrument, that they will be able to enforce against the person who assigned that to them. So if you're going to loan money to a child, you can't just then fob it off by selling it to somebody else and hope that you'll be all right, because you're going to be impacted from both directions. So what's the consequence of a void contract? Generally has no legal effect. Contracts with minors that are declared void by legislation are not treated exactly that way. The common view is that a contract that a legislation says is void will be treated the same way as a contract that is not binding unless it's ratified. So, for example, the contract can be enforced by the miner. Property and goods can pass to a miner as a consequence of delivery, but if the goods aren't necessities, the miner won't be required to pay. And where a loan to a miner is rendered void, the guarantee will not be enforceable at common law. And we spoke about that last week as one of the differences between guarantees and indemnities. When a guarantee is a secondary obligation, if I guarantee a miner's obligation and that miner turns out to be party to a void contract because they're not necessaries, then I can't be held to account. But if I indemnify, I have the primary obligation. If I indemnify someone against any loss or damage that they might suffer as a consequence of dealing with the miner, the fact that it's the contract is void doesn't matter. I have a primary obligation to hold that person harmless. I want to swap and talk a little bit about privity because I think I'm going to be continuing with privity in the tute on Sunday night. If you can just give me a second, I'll swap the recording over.